An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. NFIB, the National Federation of Independent Business versus Sebelius, 2012. In 2010, Congress passed the Patient Protection and Affordable Care Act, which regulated the provision of private health insurance and increased the number of low-income persons eligible for Medicaid that was provided by the states. The law required most Americans to maintain health insurance, and states that refused to expand the number of people eligible for Medicaid would lose all the funding they were receiving for their existing Medicaid program, which was billions of dollars. Immediately after the law was signed, it was challenged by 26 states and by the National Federation of Independent Business. Eventually, I became one of NFIB's lawyers. A sharply divided court would uphold most of the act, with Chief Justice Roberts providing the fifth swing vote. So to see what the court actually held, we need to study his opinion carefully. It's commonly claimed that the Chief Justice found the individual insurance mandate to be constitutional as a tax, but we disagree. Roberts noted that the court's previous Commerce Clause decisions, from Wickard versus Filburn to United States versus Lopez, all concern the regulation of activity. In contrast, he observed, the individual mandate
compels individuals to become active in commerce by purchasing a product they do not want. The government contends that Congress can do this because the failure to purchase health insurance has a substantial effect on interstate commerce.
This was, therefore, quite literally unprecedented. The Chief Justice stressed that even if the individual mandate is necessary to prevent insurers from discriminating against those with pre-existing conditions, quote, such an expansion of federal power is not a proper means for making those reforms effective, unquote.
Compelling people to enter commerce precisely because they have chosen not to cannot be considered a necessary and proper supplement to the Commerce Clause.
The law was improper because it was not the sort of incidental power authorized by the Necessary and Proper Clause. Rather, a power to compel people to do business with a private company, he said, was, quote, a great substantive and independent power, and beyond those specifically enumerated, unquote. Accepting the government's theory, he wrote, quote, would give Congress the same license to regulate what we do not do, fundamentally changing the relation between the citizen and the federal government. Study guide. What exactly did Chief Justice Roberts think was not proper about the mandate? Nor did he find that a legally enforceable requirement or mandate to do business with a private company was authorized by the tax power. Instead, he adopted a saving construction that construed the law not as a requirement or a mandate, but as an option either to buy insurance or to pay a modest and non-coercive tax.
The question here isn't whether the interpretation of the statute the government offers to support its tax argument is the best interpretation. Rather, under our cases, the question is whether that interpretation is reasonable or fairly possible. If it is, then the court should adopt that interpretation rather than declare the statute unconstitutional.
Although he conceded that this was not the most natural reading of the text, he said he had a duty to defer to Congress if the statute could be so read.
The Affordable Care Act's requirement that certain taxpayers pay the government for not obtaining health insurance is in effect a tax on those without insurance. Passing on the wisdom or fairness of such a tax is not our role. Because the Constitution permits it, we must uphold it.
Study guide. Did Chief Justice Roberts rule that Congress could have enacted the mandate under the tax power? Roberts then upheld the Medicaid provisions of the Act by invalidating the provision that would deprive the states of their existing level of Medicaid funding.
Threatening to withdraw a state's existing Medicaid funds if the states do not accept the expansion is an impermissible attempt to conscript states into the federal bureaucratic army.
he found that, quote, penalizing states that chose not to participate in the Medicaid expansion, which may be as much as a loss of over 10% of a state's overall budget, is economic dragooning that leaves the states with no real option but to acquiesce in the Medicaid expansion, unquote. 7 justices agreed that this option coerced the states in violation of the spending power. However, not all 7 agreed on the remedy. Chief Justice Roberts, joined by Justices Breyer and Kagan, applied yet another saving construction, whereby states could choose whether to accept the new Medicaid funding. Justices Scalia, Kennedy, Alito, and Thomas would have invalidated the Medicaid expansion entirely. So a congressional power to impose purchase mandates on the citizenry was not sustained by a majority of the court. While 4 of the more progressive justices would have upheld the act, and 4 of the more conservative justices would have invalidated the whole thing. By changing the individual mandate into an option, and by deleting Congress's threat to withhold Medicaid funding, in other words, by changing the law, the Chief Justice was able to keep the rest of the Affordable Care Act in place.
Earlier today, the Supreme Court upheld the constitutionality of the Affordable Care Act. Whatever the politics, today's decision was a victory for people all over this country whose lives will be more secure because of this law and the Supreme Court's decision to uphold it. The highest court in the land has now spoken.
Let's conclude by returning to our brief history of implied powers. Lopez and Morrison represented an effort to put the brakes on any further expansion of New Deal and Warren Court doctrines governing implied federal powers. Now, Congress could only regulate intrastate activity having a substantial effect on interstate commerce if the activity was economic in nature. Then, in Raich, by allowing Congress to reach even non-economic activity as part of a broader regulatory scheme, the court seemed to allow Congress to go beyond the high water mark established by the New Deal court in Wickard. However, in NFIB versus Sebelius, the court was not willing to extend Congress's powers beyond the regulation of economic and non-economic activity to the regulation of inactivity. This was not a repudiation of the New Deal. Rather, the Chief Justice stuck with the Rehnquist Court's stance of this far and no farther without a judicially administrable limiting principle. In other words, the court would not go beyond the line it had drawn in Wickard and then extended in Raich. Chief Justice Roberts explained that the court's decision was not
based on our judgment about whether the Affordable Care Act is good policy. That judgment is for the people acting through their representatives.
5 years later, in December 2017, the people's representatives made a different judgment about the Affordable Care Act's individual mandate.
On this vote, the yeas are 224 and the nays are 201. The motion is adopted. Without objection, the motion to reconsider is laid upon the table.
Through the tax reform legislation, Congress set the penalty that enforces the individual mandate at 0, thus eliminating the financial consequences for going uninsured. When he signed the tax reform bill, President Trump stressed that even though the Supreme Court did not nullify the Affordable Care Act's individual mandate, he would.
Many people thought it should have been overturned in the Supreme Court. Didn't quite make it, almost, but didn't quite make it. But now we're overturning the individual mandate, most unpopular thing in Obamacare. Very, very unfair.
Though the penalty enforcing the individual mandate was rescinded, the individual mandate itself and the Affordable Care Act's Medicaid expansion and other health insurance regulations remain on the books.
So we won't do the whole thing, but this is basically what it is. That's your bill.